Good morning, everybody, and welcome back to the Law and Crime Network. I'm your host, Jesse Weber, and thanks for joining us today. I want to recap what we've been covering here on the network and also talk about what we will be covering later on. As you know, the main case we've been focusing on is the Jason Riley King case out of San Diego. We're talking about that former Marine who was accused of driving drunk on the wrong side of the road, causing a head-on freeway collision that killed two people and injured three others. Now, the two people that were killed in this horrific collision were Ann Lee Baldock, who was 24 years old, and Madison Elizabeth Cornwell, who was 23 years old. Now, these two young women were two UCSD medical students in the prime of their studies and their career, so it's heartbreaking to hear that they were taken at such a young age and for such a senseless reason. Now, the three people that were injured were Jared Molitoris, Stosh Ozog, and Yuki Lazuka. You heard them testify earlier in the week, particularly Mr. Lazuka, who suffered severe brain injury, almost lost his hand. The other two individuals had severe damage to their bones. It was really a horrific accident. I shouldn't even say an accident because it's a really horrific collision. And the question is, who is at fault and what should they be charged with? Well, the main issue here is that Jason Riley King is charged with 2 counts of second-degree murder. That's what makes this case particularly unique. You don't usually see it in these kinds of cases. So he is charged with 2 counts of murder, as well as 2 counts of gross vehicular manslaughter while impaired, DUI resulting in great bodily injury, and driving with a blood alcohol content in excess of 0.14 causing injury. But what we really want to focus upon is that murder charge. As the defense keeps saying, that is the main issue in this case. They keep saying our client was overcharged. This is not murder. He didn't intend for this to happen. He didn't know that when he got behind the wheel drunk that he could be charged with murder. Well, the prosecution is saying that is not so simple. You can't say that. He knew the dangers of drunk driving. Everyone knows the dangers of drunk driving, but this guy, let alone, knew more. And you know why? He was a Marine who attended a stand-down presentation only 8 days before. And at that stand-down presentation, the police instructed the Marines about the dangers of drunk driving. And he knew what could have happened. So now it becomes a question, is this murder? Is this manslaughter? That is what makes this case unique. It should be noted that Mr. King faces 30 years to life plus 14 years in prison if he is convicted. That is a serious, serious sentence there. And this case is really providing some interesting commentary, particularly when we heard from the victims testify. But yesterday, we heard the audio of Jason King's police interview at the hospital. We also saw some surveillance footage from that night as well. We are going to play that for you in a little bit to recap what happened yesterday, as well as for anyone who knows about the case and wants to see it again. We're going to play that. But I do want to preview another case that we're covering here on the Law and Crime Network. It has been in jury selection all week, and we're going to talk about why that jury selection might be taking so long. We have a jury consultant coming in later on, Alan Turkheimer, to talk about it. But what we're talking about is the William Woodward case out of Titusville, Florida. I want to play for you right now a short preview, a trailer, if you will, of what you can expect in that case, and then we'll talk about it in a minute. Take a look. Labor Day weekend 2012. What should be barbecues, fun, and celebrating turned into murder. William Woodward of Titusville, Florida is accused of shooting and killing 2 neighbors and injuring a third. And it was all captured on surveillance footage. The man who prosecutors say dressed in camouflage and hid in the bushes for this surprise attack is now claiming self-defense. His defense attorneys say Woodward was provoked for months and that the community supports his actions. And that's not all. Reports indicate that Woodward, who is a war veteran, may suffer from PTSD and a brain injury. Stakes are high in this case as Woodward could face the death penalty. Labor Day weekend 2000. constantly here on the Law and Crime Network about whether or not this defendant was justified in using force. We see these self-defense cases constantly, and the question becomes, will this defendant take the stand? I might be jumping the gun a little bit. The case hasn't even started. It is still in jury selection. We hope for there to be a live feed sometime tomorrow, sometime on Tuesday when the holiday is after the holiday weekend. But as soon as we do have some more information or a live feed in that courtroom, we'll go to it. So that is the William Woodward case out of Titusville, Florida. That is the second case the second trial we will be covering here on the Law and Crime Network. What I want to do for you right now is play for you a new special segment. This is a new case that we are covering. This is a really, really disturbing case that we want to talk about this morning. It appears that there is some trouble brewing in Colorado. School officials in Prairie Middle School in Colorado have been indicted for failing to report child abuse, namely that of a teacher, Brian Vasquez. And what is that child abuse? That he sexually assaulted a student, a minor, a 14-year-old girl. And now instead of telling the police, which the school officials were required to do by the law, these officials, which include the principal, the assistant principal, and a counselor, conducted their own investigation. They allegedly, and I want you to hear this, they allegedly questioned the student in the same room as the teacher. Think about that for a second. They questioned this underage student in the same room as the teacher. That is what the allegations say. And when she was questioned about it, she eventually recanted her story, and the school officials suspended her. Now, according to the indictment, she had to apologize and hug this teacher, Mr. Vasquez. The problem for the school? That allegation turned out to be true, according to police. They claim the teen was just one of several girls that Vasquez molested. The youngest was 14 years old. When questioned by police, this teacher not only confessed, but offered the names of 4 other victims, according to his testimony. This former teacher originally faced only 8 counts, but that got bumped up to 31 felonies. 31 felonies. So now this teacher and these school officials are in some pretty hot water, and we want to talk about this case in more depth. And joining me right now via Skype is former federal prosecutor Kendall Coffey. Kendall, good to see you here on the Law and Crime Network.
Hey, good morning, Jesse. Thanks for including me on your show today.
Of course. This is pretty disturbing, to say the least. This guy, let's start off with the teachers, okay? This failure to report, okay? This is an allegation that we hear. Now, isn't the school district, if you want to take it from one side, isn't the school district allowed to conduct their investigation first before they call the police?
Well, I don't think there's necessarily anything inappropriate about taking some preliminary look. But Colorado, like most states, do have laws that require that child abuse be reported. And so from the standpoint of a school, not necessarily should every whisper of an allegation require a police report. But I would suggest that when a child comes to school officials and explains an allegation of being abused in some way, and if it's not incredibly obvious that it's utterly false, in other words, a situation where the child changes her story 3 times in 3 minutes, then I think they should report it, because at the end of the day, who are the professionals in education? Well, we know it's the principal, it's the assistant principal, but who are the professionals in investigating possible crimes, possibly very serious crimes? That's the police. And so I think they, bluntly speaking, were wrong to begin with. And then it went from there in a way that was a nightmare. This child was doubly victimized, triply victimized, first by the school teacher, but then by officials. It's kind of shocking to imagine a situation where somebody is forced to deny the truth, pressured in an excruciating way, and then required to apologize and hug the abuser. So this is not an everyday case where school officials could have, would have, should have been a little more vigilant. This is an extreme case, and I think it's very, very fortunate that the prosecutors, assuming the allegations are true, are going forward with criminal charges here.
I mean, Kendall, the idea here that she had to talk about what her allegations in front of the teacher. I don't care what kind of investigation is. How does someone do that? You never have someone, no matter what kind of investigation it is. Have you ever heard of a situation where you have to speak about the person to their face?
Only if it's some form of a kangaroo court. Sometimes in an employment situations, if an employer wants to be sure that the accuser is discredited, maybe they'll have for example, the manager sitting in the room. But you do that only if you already decided you intend to destroy the credibility of the accuser or pressure the accuser into changing it. From just a pure investigative standpoint, there is no possible rationale for requiring that a child sit in the same room with the alleged perpetrator to discuss the matter.
Now, these school officials, at least two of them, one of them is no longer at the school district, but the other two have been suspended. What do they face legally in terms of this misdemeanor charge of failing to report child abuse or neglect? What are they looking at?
Well, up to now, it's a misdemeanor, and a misdemeanor means it's basically less than a year. But what I would suggest is that this case has a broad importance, because reporting child abuse is something that, as I say, most states have laws about that, and the states don't require that everybody in the universe has a criminal obligation, a criminalized liability. But individuals who are in positions of trust, in positions of care, typically including teachers, because they do have a position of trust with respect to our children, those are folks that have a duty to make reports. And I'm hoping that throughout the country, others who are in positions of trust with respect to children, especially educators, are paying close attention to this case. These administrators are not facing long-term prison sentence, but they're obviously facing the destruction of their careers and literally some time in a jail. And when we look at the very extreme circumstances of this case, assuming the allegations are proven, this kind of consequence for these administrators would be fully deserved.
How do they defend themselves? Do they say, okay, we didn't try to cover this up. We weren't protecting Mr. Vasquez, Brian Vasquez. We weren't trying to do that. We just conducted what we thought was a proper investigation. We've had investigations like this in the past. This is how we did it. How do you defend against their actions if these allegations are true?
You've already kind of, I think, signaled a little bit of what they would try to say. I think they would try to say that, well, we're not professionals, but we, of course, get nonsense, gossip, students all day bad-mouthing teachers, and we would say making up all kinds of stuff. So that would certainly be part of it, to just say, we're just educators, we do our best, we hear a lot of stuff, we don't bring the police in if we think it's absolutely untenable. And the other thing that most folks try to do, which I don't think would be very successful here, is to some extent put the victim on trial if they can by saying, well, you know, she was somebody that had, you know, around the school, she had a reputation for making up stuff. She wasn't considered a credible person with respect to accusations. And I don't know if they'll actually try to say that, but when we theorize all the different possibilities. But as you were highlighting and emphasizing, whatever they try to say about their skepticism, if there was a skepticism, then how do you go to the situation where their investigation is done with a teacher in the room? Where do they get that from? And then how do they justify requiring a student to apologize after recanting and hug the accuser?
I think, Kendall, I think that's really where it is. I think that's really where their whole argument would fail. I think you nailed it right on the head, and I think that's going to be extremely hard for them to explain away. But I do want to talk about this teacher, the main focus here, this guy, Brian Vasquez, who is alleged to have sexually abused multiple students, multiple underage girls. What is the process for prosecuting this guy? Didn't he admit everything, or does he still have some sort of case here on his some sort of defense?
Well, apparently he did indeed admit core allegations and even identified other victims to the police. And in fact, that's what prompted the prosecution of the school officials once they since had the same individual who the school officials went out of their way to clear and exonerate. Once he indicated that in fact he was the perpetrator and he did these things, that's when they realized that that the conduct committed with respect to the initial accuser was just very, very wrong. His defense is a tough one. I don't. It's very difficult to think that he can secure a not guilty under any circumstances, and you've got to think that he's just trying to develop some kind of explanation about psychological problems, something that softens the inevitable prison sentence. Because guys in this position nowadays can go to prison for a very, very long time. And often they should.
31 felonies. 31 felonies. If all these allegations are true and he is convicted of 31 felonies, I imagine he's never coming out of prison, right?
I think that's a foreseeable scenario. And the battle in this case for his lawyer is to try to get him some piece of his life back 15 years from now, 20 years from now. But he's going in for a long time.
And the conversation that you said about psychological issues, his background, that all comes into play in if he's convicted in the sentencing hearing. We kind of saw that in other trials before, even murder trials, where we talk about how people were brought up, brain injuries that they suffered, traumatic injuries, and how that affected their actions. But that doesn't necessarily always work, correct?
It very rarely works on the guilt phase. But sometimes individuals who are abusers were themselves victims of abuse. And you and I are just talking broadly, theoretically.
Sure.
We don't know at all what the defenses will be or what the facts are here. But sometimes it's a fact that abusers were victims themselves during their childhood of abuse. And while that doesn't erase responsibility in terms of guilt or innocence, it can sometimes chop down the number of prison years because some judges will really take that into account.
So, Kendall, how do we prevent this kind of behavior from happening in school districts? Again, assuming all the allegations are true, how do we prevent this behavior? And we see it throughout the nation of child abuse in this way and teachers taking advantage of the position. How do you prevent this in school districts?
Well, I think you've got to have a system that, frankly, has a very modest threshold for reporting things. Mm-hmm. This isn't a matter of probable cause. This isn't a situation where school administrators should think that they're police officers and they're going to get together as a judge, jury, and prosecutor and decide whether there's guilt beyond a reasonable doubt. The threshold has to be much less than that because educators aren't professional law enforcement officers. And so and however you would articulate the test, in making law enforcement judgments, we have a range of standards. But I think that if a complaint is made by a child and it isn't incredibly obvious on the face of it, like, the child being self-contradictory in ways that are significant, and if it's not inherently implausible, it's got to be reported and then meaningfully investigated. And look, that's not fun for people who are accused and are innocent. And sometimes in some situations, it goes overboard. I'll just give you or people think it goes overboard. I'll give you another example. In nasty divorces, spouses sometimes accuse each other of child abuse. And of course that can be used as a tool in some situations. I don't really think that that occurs with any frequency in schools. Mm-hmm. But even if it forces somebody to go through what they consider to be an undeserved investigation, where they're confronted and they're asked questions, and I think that there's no merit to it, either because there's a motive behind it, it's still something that the system needs to have. It's obvious that there's just too much risk to children, and we've learned over the years just how many unreported cases there are of abuse and how many times it shatters lives of victims. So unfortunately, while I don't believe that the presumption of innocence should be denied, and I don't believe that anybody should be punished or sanctioned unless there's actually provable guilt, I think the reporting and the investigative process have to be